Morning, Erica, Marcus.
Morning, everybody.
Morning.
Good
Thought we'd
morning.
give another minute or so and see if we can get everybody in here before we start.
Yeah, I thought we had a couple of other folks that were joining us too. So,
I'm here, Ladora.
hey, Ladora, I don't see you. I just saw a name earlier. So,
I'm here. I don't see me either. I just see my name.
okay, okay. Well, welcome.
Thank you. Thank
I see Christy coming on.
Can y'all see my PowerPoint on screen?
you. Yes.
Okay, it should be working then.
Okay. All right, Amy. If it's 10:03, so if you want to go ahead and get started with your introduction, we can go from there.
All right, well, welcome everybody to our training for the governing boards for charter schools. We have Tom Hood with us here today. He is the Executive Director and General Counsel at the Ethics Commission. So we are very happy to have him speaking to us today about ethics and government, open meetings, and public records, which should be really, really good information to have, of course. While you are listening to his awesome presentation, I would like for you to think about other items or subjects that you would like to have training about. We're trying to put together some other trainings for governing boards. So if you have any suggestions of things that you want to learn about or know more about, I'll ask y'all again at the end when we do a question and answer session after Tom gets done with his presentation. I'll ask y'all again about what you if you have any suggestions for things to do trainings about. Do I see Claire here? I don't think I do.
I don't yet.
Okay, so we'll cover that when if she comes in, and then we'll have a special guest at the end. I don't think he's here yet either, so we'll cover that when we get there. So Tom, if you're ready, if you'd like to go ahead and get started, that would be great.
Yeah, and I'm supposed to go till 11, is that right?
Yes.
Okay. Well, I apologize, but I'm gonna try to cover way more than an hour's worth of information in an hour. So I'm gonna go fairly fast. But if you have any questions, please stop me. And I'll take those now or later. So the Ethics Commission does several different things. Our main function, of course, is under the ethics and government law, and we have three main areas of responsibility there. We handle the statements of economic interest that elected officials and a lot of other folks have to file with us. We investigate violations of the ethics law by people in state and local government, and we issue written advisory opinions to anybody who's subject to the ethics law and wants our advice. And all those are posted on our website. They're searchable. All this information I'm going to give you today is all on our website. It's a good resource for you. And you're welcome to a copy of this PowerPoint as well. We also enforce the Open Meetings Act and the Public Records Act. You'll see as we go through today, all three of those laws cover members of charter school governing boards. So that's why I'm covering all three topics today. We also have a couple of minor roles under the campaign finance law, which are not applicable to charter school folks. So I'm not going to cover that today. We're going to start with the ethics law. There are 8 basic prohibitions in the ethics law. The ethics law is not all about prohibitions, but that's the main thing that you need to have some awareness of. And so we'll start with this brief little outline, and then we'll come back and talk about some of these provisions in more detail. Members of public boards, like charter school boards, are subject to some restrictions that other folks in government are not subject to. So we'll come back and talk about that. But board members are sort of held to a higher standard, particularly when it comes to contracts with the board. The rest of this applies to everybody in state and local government. You can't use your office or your position in government to get a monetary benefit for yourself, your relative, or your business. You cannot be a contractor, subcontractor, or vendor to the governmental entity that you serve. You cannot buy goods and services from the governmental entity you serve other than utilities and some items like that. If you're a member of a board that issues bonds, you cannot buy those bonds directly from your own board. There's an exception that allows people to buy those on the open market. That almost never comes up. A provision that I call insider lobbying, it basically says you can't get paid to influence a decision of your own board or your own office. That would normally constitute bribery in most circumstances. Most people know you're not supposed to do that, so we don't have to cover that in detail either. There's a provision I call post-government employment. It applies to people after they leave government, and it can restrict what they do if they go out in the private sector once they leave government. And then finally, a provision I call insider information. It basically says if you get some information through your government service and that information is not public and you share it with somebody, you can be liable if they make money off of it. So the moral of that story is if you, through your service to a charter school, if you happen to come by some information that has some economic value and it's not known to the public, keep it to yourself. I think that's probably much less likely to come up with charter school boards than with traditional public school boards because of the real property interests are different. But it could come up, and it's at least good to know that it's there. Okay, so Section 109 of the state constitution is the foundation of Mississippi's ethics law. It has been in the Constitution since 1890. The Ethics Commission wasn't formed until the late 70s, so there's some background here that predates the Ethics Commission. But this is the part of the law that applies to board members, legislators, members of state and local boards and commissions, but not to other people in state and local government. So it says if you're a member of the legislature or a public board, you cannot have an interest in a contract that's authorized by your board during your term of office or within a year after you leave office. So if you're a member of a charter school governing board, you cannot have an interest direct or indirect interest in any contract. Remember here is that the term contract is very broad. We normally think of formal contracts like a construction contract or an employment contract, but it really covers anything involving the payment of funds in exchange for the receipt of goods or services. So any sort of business transaction is going to involve some sort of contract and will be covered under this law. The other important things to remember are that, as I said, it only applies to members of the board and members of the legislature. So employees of schools are not covered. Members of the governing boards are. There's got to be some sort of contract. As I said, it doesn't have to be a formal contract. It doesn't have to be in writing. Any kind of transaction would constitute a contract. The violation happens or the conflict arises when the board takes an action to authorize that contract. The individual member we're talking about who would have the prohibited interest doesn't even have to participate in that action. So it's a prohibition against an interest. It's not a prohibition against an individual taking some action. If the board authorizes the contract and the member has a prohibited interest in the contract, then that individual member is violating the law, even if they didn't vote or otherwise participate in approving that contract. The other thing, obviously, is that this continues to apply to somebody for a year after they go off of the board. So if you'll see in a minute, if you're an example of this, if you're on the board, you can't be an employee of the board while you're on the board. You also can't work for the board for a year after you go off of the board. So this has sort of a trailer that hangs on after you leave office. That's also important for folks to remember. First and foremost, it's important to understand that the reason that we're here is it's because charter school governing board members are public servants, as that term is defined in the ethics law. That means charter school governing board members are subject to all these provisions in the ethics law that everybody else in state and local government are subject to. There's sometimes some confusion about the status of charter schools, and they are different from traditional non-charter public schools. but they're still covered by all the laws that we're going to talk about here today. So it's important to think of charter schools as traditional public schools in the sense that all of these accountability and transparency laws do apply to charter schools the same way they do to non-charter schools. The issue or the question in this particular opinion was whether one individual could serve on the charter school board and the local non-charter school board. Technically, that's not absolutely prohibited, but it certainly raises an appearance of impropriety that's inconsistent with the public policy section in the ethics law. That's not something we're going to cover in detail today because it's not one of the prohibitions, but it sets the tone for how everybody in government should act. It basically says we should all pursue a course of conduct that does not raise suspicion among the public that we're violating the public trust. So public service is a public trust. When you're on a charter school board, you're in public service, and you have to maintain that sort of standard of conduct. A little further example, and these are summaries of opinions. As I said, all the advisory opinions on our website. You can go search them and read them. These are just sort of blurbs that make the point. The actual opinions are a good deal more complicated than this, but I've tried to summarize these basically to fit on the PowerPoint screen. But this is a follow-up opinion of that first one. A charter school governing board member may not do business with, the board may not do business with a board member's employer. This is a basic rule that applies to members of all public boards in Mississippi, whether it's Board of Aldermen, Board of Supervisors, traditional school board, or a charter school board. You generally are going to have a prohibited interest in your employer's transactions and your employer's income. I like to say if the money is making a circle, then you probably have a problem. Here, the money would leave the charter school, go out to a vendor or contractor. That business will take that money, put it in the bank, and pay their bills. And most businesses' biggest bill is their payroll. So the money is going from the charter school to this business and back to the employee who is a member of the charter school governing board. So if the money is leaving the charter school and coming back into a board member's household, then you're probably going to have a problem. So this is the same rule that applies to all those other types of public board members. Here, it's just applied specifically to a member of a charter school governing board. So bottom line there is if you've got a day job, your employer probably cannot do business with your charter school. We're going to talk about recusal in a minute under the next part of the law, and I'll tell you how it's not a magic bullet. Here, the important thing to remember is that simply recusing yourself from this transaction would not prevent a violation of this part of the law. An employee of the school district cannot continue to be an employee of that district after they become a member of the school board. So let's say somebody is an employee of a county school district and they want to run for school board. They can do that, but if they get elected, they're going to have to quit their job in the school district before they take office on the school board. Even though charter school board members are not elected, the same basic principle would apply. It also applies to municipal school districts, boards of aldermen, boards of supervisors, every kind of public board or commission in the state. You cannot be an employee of the board that you're a member of. And once you leave that board, you can't be an employee of the board for 1 year after you leave office. Here, as we told this person, if they got elected, they had to quit their job before they took office. If you're working for a charter school, you got to quit that job before you become a member of the board. This is a similar situation, but a little bit different because we're talking about a nonprofit. And the important thing to remember here is that a nonprofit can be a business under the definition of business in the ethics law. Here, this nonprofit was a business because it's receiving public funds. That's the essence of that part of the definition. And so this nonprofit was contracting with the local school district. This employee of this nonprofit wanted to become a member of that school board. And we said the same thing we said to the previous person. If you're elected to the board, either you're going to have to quit your job with the nonprofit, or the nonprofit will have to terminate their contract with the school district. Why? Because you have an interest in the contract between your employer and the school board. And so that is where the problem arises, is the contract between the employer and the school board. So this person, like a lot of folks, was not told what to do exactly by the ethics law, but the ethics law forced this person to make a choice. And fortunately, this person found that out before they became a member of the board. I think they were running for election. They decided to withdraw. They decided to choose their job over service on the school board, and withdrew as a candidate for school board. What about spouses? Under this part of the ethics law, normally, if the board member can't do it, their spouse can't do it either. And here's an example of that. The spouse of a school board member may not be employed as a substitute teacher by a company that contracts with the school board to provide substitute teachers to the district. School board member would have a prohibited interest in the contract between their employer and the board. That's because the Supreme Court has said we all have an interest in our spouse's income because we live together and share expenses. You could say the same thing about anybody who has a common financial interest with a board member. So here it's the spouse. It could also be somebody who lives with them, who they're not married to, even a roommate. It could be their child who lives with them. It could be their business partner, could be somebody who owes them money. So anybody who has a common financial interest with a board member may be prohibited from doing business with that board directly or indirectly. So this is an example of how this part of the law sort of reaches out past the board member. To further that example, the best of my recollection, this company, that district. So this board member's spouse was not working in that school district. They were working in a different district, but they were working for the same company that this district contracted with. That was a problem. It creates that circle of money that I talked about earlier. And so that's why it was prohibited under these circumstances. Moving on to the next part of the law. So we've talked about the part of the law that applies only to board members. The rest of the provisions we're going to talk about apply to board members and everyone else, administrators, employees, etc. If you're a public servant, that's the term that's used in the ethics law. If you're a public servant, you're covered by the ethics law. So again, charter school board members are public servants. You can't use your position to obtain or attempt to obtain a pecuniary or monetary benefit for yourself, your relative, or any business with which you're associated. So can't use your position with the school to get a monetary benefit for yourself, your relative, or a business with which you're associated. We'll talk about what those terms mean in just a minute. How does this law apply? It does not require that you misuse your position. I like to say you don't have to do anything unethical to violate the ethics law. Using your position is just doing your job. And so for a member of a charter school board, your job or your duties primarily consist of going to meetings, deliberating matters on the agenda, and deciding them or voting on them. So you basically deliberate and vote. Those are the things that you do. Those are the ways you use your position. To avoid violating this part of the law, either the other person doesn't get the monetary benefit or you don't use your position. Not using your position is called recusal. And that's the most common way to avoid violating the law. For a board member, that's pretty easy to describe. It just means you get up and leave the room. You're absent for part of the meeting. You don't come back until after that matter is concluded, and you don't talk with anybody about it. We'll look at some examples of that in a minute. Now, to contrast that, an abstention is not a recusal. An abstention just means you don't vote. You could still sit in the meeting, talk about the matter all day long, express your opinion, and that would be using your position. So that's why an abstention is not good enough. It also, an abstention usually counts with the majority under most circumstances, even though you didn't vote. You're also present for purposes of a quorum. So it's still using your position. In order to avoid violating this part of the law, you have to completely avoid using your position, which again is called a recusal. Now, remember, we showed an example of this a few minutes ago. Recusal does not prevent other violations of other parts of the law. So remember the 8-bullet point outline at the beginning. Recusal only fixes one of those 8 potential violations. It doesn't help with the others. So if you have a problem under Section 109, as I mentioned earlier, you can't just recuse yourself out of it. It's a deal killer under Section 109. If there's a potential violation under this subsection, recusal will fix it, but not the other potential violations. So who's your relative? If you can't use your position to benefit your relative, who are we talking about? Law says it's your spouse, your child, your parent, your siblings, and anybody who's married to any of those people. That gets confusing, particularly when you talk about the spouse of a sibling versus the sibling of a spouse. The spouse of your sibling is your relative. The sibling of your spouse is not. They're both called your brother-in-law and sister-in-law. One type is your relative, the other is not. So that's one big point of confusion. This is not the definition we asked for. This is the definition the legislature gave us. And so this is what we have to work with. There's also a Supreme Court case that says stepchildren are not relatives for purposes of the ethics law. But the legislature comes back and says the spouse of your parent is your relative. So a step parent is a relative, a stepchild is not a relative. Again, it's not what we asked for, but it's what the legislature gave us. It's confusing. If you ever have a question about that, feel free to contact us and ask us. Here's an example of what we're talking about. You've got somebody who's just become a member of their local board, school board. They have a sibling, a relative who's already working for that school. Here we see that the school board member and the sibling are financially independent. Why does that matter? It matters because of what we talked about in the last set of slides under Section 109. The board member and the other person have to be financially independent. Remember, I said if the board member can't do it, the spouse probably can't. And that's because the Supreme Court has said we all have a financial connection with our spouse. You could have a financial connection with somebody else. It could be your sibling. What if you own a business together? You own the family farm together. You have common debt on the family farm. That would make you financially connected, not financially independent. So that's important under the previous part of the law we talked about. Here, those two people are financially independent. So this is not a deal killer. The sibling can remain employed by the school after their brother or sister goes on the board, but the board member will have to recuse himself or herself from any action by the board that would put money in their brother or sister's pocket. Why? Because you can't use your position to get a monetary benefit for your relative. So we're talking about hiring the relative, increasing pay or benefits, anything that puts money in the relative's pocket, the board member will have to recuse from that action to avoid a violation. In this example, school board member has another financially independent relative. They're employed by the district. Can they vote on the district's budget? No. This could apply, although differently, in the charter school setting. If you're voting on anything, again, that's going to fund your relative's employment, make it possible for them to continue their employment. In this situation, we created a sort of rule of necessity and said, you have to recuse from the budget if your relative works there, unless your recusal would result in the loss of a quorum and render the board unable to act. So there is a sort of escape clause there that can be helpful in those situations. And I'm sorry, I thought I had deleted this slide from this presentation because this is not going to apply to charter schools. So apparently my delete button didn't work. We'll skip that one. Okay, business with which you're associated. So you can't use your position with the school to get a monetary benefit for yourself, your relative, or a business with which you're associated. What does that mean? That term is defined in the ethics law as any business with which you or your relative has any of these connections: position, ownership, income, or control. So if you or your relative has any of these connections to a business, then it is a business with which you are associated. It can probably do business with your school, but you can't participate in anything that benefits the business, such as paying a bill submitted by that business, or approving a contract with that business, or anything else that's going to result in a monetary benefit to that business. You'd have to recuse yourself if the business meets any of these criteria with regard to you or your relative. Here's an example. Insurance agent can he continue to write insurance for a school district after his financially independent son is appointed to the school board? The answer is yes. So the insurance agent's son is on the board. Can the insurance agent sell insurance to the school? Yes, he can, because they're financially independent, but the board member / son will have to recuse from anything that would benefit the father or the father's business. Here, any benefit to the business is probably going to benefit the father because he's the agent. But what if the father was not the agent? What if he was just an employee of that insurance agency who was not going to get a commission from selling this policy, for instance? The board member would still have to recuse simply because his relative is an employee of that business. So you got to recuse even if your relative is not going to benefit. Contractor prohibition. You can't be a contractor, subcontractor, or vendor with your own school. You also can't have a material financial interest in a business that's a contractor, subcontractor, or vendor to the school. So for board members, this sort of overlaps to a large extent with Section 109 and subsection 2 that we talked about earlier. For employees, this does not overlap because they're not subject to those other provisions. Here's an example. Business owned by a school teacher may not serve as a contractor to the school that employs that teacher, simply because this subsection prohibits that teacher from having a material financial interest in a business that's a contractor to their own school. That term material financial interest is defined in the statute as well. It's a very complicated definition that I won't get into right now in detail, but there's a $5,000 annual income threshold. So if you've got an employee who's got a side business or they're moonlighting, that's fine, but their business probably can't do business with the school. Here's another wrinkle that comes up under this subsection. You can't have two separate positions with the same school. Can you wear different hats? Yes, you can. Can the administration give you additional duties? Yes, they can. They can even pay you for those additional duties. But you can't have two separate jobs or have two separate contracts of employment with the same school. Sometimes that's a distinction without much of a difference, but it is an important rule to observe. Purchase or prohibition. You can't purchase anything from the governmental entity you serve. So if you're associated with a school, you can't purchase anything from that school. I don't know to what extent charter schools are selling things. As I mentioned earlier, they don't have generally the same property footprint that traditional schools do, but this could come up, and it's important to know in case it ever does. Some examples that come up in the traditional school realm are surplus auctions and tax sales. Those probably are not going to come up again with charter schools, but there may be an analogous situation. Another important thing to remember about these last provisions we talked about is there are some exceptions to these provisions that are in subsection 3. The exceptions don't apply to all 8 prohibitions, but they do apply to the ones that are contained in subsection 3. That means they don't cover you if you've got a section 109 problem. They don't cover you if you've got an issue under subsection 1 where you'd still have to recuse yourself. So you can think of these provisions as separate hurdles that one person might have to clear, maybe 3 hurdles in one circumstance. Sometimes people ask us for our advice and we have to answer 3 different questions or analyze one question under 3 different parts of the law to give them one answer. So this is a sort of multi-step analysis that we have to go into to answer these questions. Post-government employment, I mentioned that earlier. When somebody leaves government, they are still under some restrictions after they're out in the private sector. This essentially says you can't go out in the private sector and get paid to work on the same matter that you worked on while you were in government. Here's an example. This person was not prohibited from going out and they probably retired, but they left government and turned around and contracted directly with their former governmental employer after they retired. That's not an issue. It only becomes an issue when they're working for a business. Okay, so that was really quick, but we're going to move on now to talk about the Open Meetings Act. Again, if anybody's got any questions, feel free to send those my way. How do we enforce the Open Meetings Act? We didn't talk about ethics enforcement. I didn't really have time for that. This is a totally different process. It's very similar to the public records enforcement process, though. Somebody files a complaint with us that alleges a public body violated the Open Meetings Act. We send that straight to the board. They file a response with us. Once we have the complaint and the response, if we have enough information, we on the staff can write a recommendation to the Ethics Commission that they either dismiss the complaint or find that a violation probably occurred. We can hold administrative hearings in these cases. We don't usually have to do that, but we can to gather facts. If the Ethics Commission determines that members of a public body violated the Open Meetings Act, they can fine individual board members $500 for a first offense or up to $1,000 for a subsequent offense. That does not happen very often. It's only happened in very egregious first offense cases and for repeated offenses. In other words, somebody's been told not to do it. We get another complaint, they do it again, then they might get fined. If you don't like the Ethics Commission's decision in these cases, you can appeal it to your local chancery court. What are the basics of the Open Meetings Act? Public meetings of public boards have to be open to the public. The only way you exclude the public is to go into executive session. You have to follow a specific procedure, and you can only do that for certain reasons that are listed in the statute. Two other requirements are notice and minutes. You got to provide notice to the public of when and where you're going to meet, and you got to keep minutes of your meetings, and we'll talk about those specific requirements in a minute. If members of a board get together for a social occasion, that's fine. It only becomes a problem when a quorum is discussing board business, or in your case, school business. And then also just to point out what's probably obvious to everybody, the Open Meetings Act includes charter school boards in the definition of public body. So the Open Meetings Act explicitly applies to the governing boards of charter schools. What is a meeting under the Open Meetings Act? Here's what the Supreme Court has said in its latest decision. This was a case involving the City of Columbus City Council. They had 6 members, so it took 4 to make a quorum. 3 met with the mayor in the morning, 3 met with the mayor in the afternoon. They never had a quorum in one room at the same time. They said it wasn't a meeting because we never had a quorum gathered together at one time. But the Ethics Commission said, doesn't matter. You got all 6 members of the board together and you talked about the same matter of board business with the same person. Just because you split up your quorum into separate groups doesn't mean you get around the Open Meetings Act. You actually had a meeting even though you didn't have a quorum in the same room at the same time. They appealed that to Chancery Court. Chancellor agreed with the Ethics Commission, went to the Supreme Court. The Supreme Court obviously also agreed with the Ethics Commission. So just splitting your quorum up, having what's sometimes called a piecemeal quorum or walking quorum, where you never gather a quorum at one time, that's not good enough to avoid a violation of the Open Meetings Act. If a quorum is talking about a matter of board business, then that should only be done in a properly noticed public meeting. Here's a case involving a different kind of meeting. This board had a retreat. A retreat is another name for a work session. It's just a work session that happens off campus, so to speak. Lots of boards have work sessions. It's generally regarded as a meeting at which you've agreed you're not going to take any action. You're just going to talk. So a retreat, a work session, they're both meetings. There are other names for meetings, but if it fits all the criteria, if it checks all the boxes in the law, then it's a meeting under the Open Meetings Act. You don't have to vote at a meeting for it to be a meeting, because the Supreme Court has said deliberations are official acts. And so if a quorum is deliberating board business, that's a meeting. At the retreat, they didn't have a vote, but it was still a meeting. Guess what else you got to do? You got to keep minutes of every meeting, even if you don't vote. Minutes of a work session are going to be very short, and we'll talk about the requirements of that in a minute, but you still got to keep minutes at every meeting, even if there's no vote. The other thing that came out of this case was committees. The definition of public body in the Open Meetings Act also contains the phrase "or committee thereof." So if a public body creates a committee, then that committee is also subject to the Open Meetings Act. It has to provide notice of its minutes of its meetings and has to keep minutes of its meetings. Here's a sort of corollary to that. So we said in this last case, if the board creates a committee, then the committee has to abide by the Open Meetings Act. Here, the superintendent of this county school district created a group, and somebody wanted to go to the meeting. They weren't allowed in. It wasn't open to the public. And the Ethics Commission said, when the superintendent created this panel, that's not a public body, because a public body can only be created by another public body. A committee thereof can only be created by the big board, so to speak. So the school board, the board of the school could create a committee, but an administrator cannot. And so if an administrator creates a group, it's not subject to the Open Meetings Act. If the board creates the group, it
Okay.
probably is subject to the Open Meetings Act via email, but you can violate the Open Meetings Act by email. In this case, the executive director sent out an email to all the board members about an agenda item. The board members started emailing each other about that agenda item and what they wanted to do about that agenda item. They were deliberating. They were deliberating board business via email. That's not legal. They can only deliberate board business in a properly noticed public meeting. In all of our email cases, we've tried really hard to explain to folks that email is not necessarily a bad thing. It's a great tool, particularly for central office people, administrators, to communicate information to board members. It only becomes a problem when board members use email to communicate with each other. Here's another example. Next case we had involving email. This was one board member emailing the other board members. There was no evidence that the other board members emailed back, but the Ethics Commission still said that's a problem because this one board member was trying to influence a decision of the other board members about board business. So again, we reiterated board members should not use email to communicate with each other about board business. They should not forward or copy emails to other board members. Administrators or staff are free to use email to send information to board members or communicate back and forth with board members, but they should blind copy the board members so that the board members don't accidentally email each other. Because when you blind copy somebody, if they respond to all, it only goes back to the person who sent the email, and that would avoid an unintentional violation of this part of the law. We've also applied this to text messages. We've had cases on that. So board members shouldn't be texting each other about board business either, shouldn't be emailing each other about board business. It really needs to be limited to a properly noticed public meeting. What about telephonic meetings? Boards can meet by telephone. They can be in different locations. Everybody can be on the phone. Some can be in the boardroom. But even if nobody's in the boardroom, you need to have a speakerphone or some sort of equipment in the place where you normally meet so that if members of the public come in, they can hear or see what's going on just like a board member can. The practical side of that is you got to vote in a way that everybody can understand who's voting how. The guy on the phone can't see a show of hands, so you've got to have a roll call or some sort of voice vote. Phonic polling. I didn't realize this was still an issue until recently. The Supreme Court said in 1985 that you can't call board members and poll them on an agenda item. In other words, it's not legal for somebody in the office to call each board member and say, hey, we got this thing we need some action on. How do you vote on it? You can only do that in a telephonic meeting. It's really easy to set up a telephonic meeting. If something comes up, you need the board to act on it quickly. You call a special meeting, you provide public notice of that, which we'll talk about in a second, and you do it by telephone. You can do that in the span of a couple of hours, set that up, have a telephonic meeting, legally vote on the thing that needs to be acted on, and move on. Can members of the central office, administration, employees, can they call board members and ask questions or have conversations? Sure. You just can't poll the members in the sense that you're getting them to vote over the phone one by one. That has to take place in a properly noticed telephonic meeting. What about executive session? This is probably the trickiest part of the ethics law, is getting this procedure right. We'll look at the procedure. This is what the Supreme Court has said about the procedure. They basically said it's hard to go in executive session. We're going to make it hard to go in executive session because then you won't do it unless you really need to. So the Supreme Court and the law discourage boards from going into executive session unless they have a valid reason. Here's the procedure in brief. This is what the Supreme Court said about it in 1989. You got to start in an open meeting. Somebody has to make a motion for a closed determination. This is the part of the meeting where one board member can close the meeting to tell the other board members what they want to talk about in executive session. Sometimes this is not necessary because everybody knows why you need to go in executive session. It's on the agenda in general terms. And so it's clear to everyone that you're going to need to go in executive session under a particular reason. But the Supreme Court said you can't skip any steps, so you can't skip this step either. We have said that the board can make the closed determination in the open when it's appropriate to do so. That's a convenience, so you don't have to make members of the public or other folks leave the room. You could do that in public in those situations where everybody knows you've got to go into executive session. There can be circumstances, though, where only one board member has the information. Maybe an employee has told them allegations of sexual harassment. They can't share that in public, so they have to make this motion for closed determination. It briefly closes the meeting, and then you talk about whether you need to go in executive session. The board has to vote by 3/5 majority to enter executive session. Then you've got to tell the public by stating in open session why you're going into executive session and who voted how on that vote. We're going to talk about those reasons in just a second. That's another tricky part, but you've got to tell the public in as much detail as you can why you're entering executive session and who voted how. The reason and the vote have to be recorded in the minutes. If you happen to have a meeting that rolled over to a second day, or you take some other sort of long recess, then you have to start that process over again when you reconvene and go back into executive session. What are the reasons for executive session? There are several in the statute. The Supreme Court has said you have to state those reasons to the public with sufficient specificity so that the public can later check it out. You can't just say we're going into executive session for personnel matters or litigation. The Supreme Court has specifically said that's not enough. It's not sufficiently specific. You've got to give more information. The tricky part is giving enough information without giving too much information to the public, because you don't want to defeat the whole purpose of going into executive session. Here are the reasons in a summary bullet point format. The best advice I can give you on sufficient specificity is to read the statute. Don't leave out any of the parts of the statute. So for instance, subsection B allows you to go into executive session for prospective or current litigation. So a lawsuit that's already been filed, or a lawsuit that's under consideration or has been threatened. That part of the statute says you can only do that when an open discussion, an open session, would have a detrimental effect on your litigating position. So when you state your public reason and you put that reason in the minutes, you need to include that part of the statute. It needs to say that the board determined that having an open discussion would have a detrimental effect on the board's litigating position. So you got to include all the elements of that statutory reason. Personnel matters, for instance, it includes items like professional competence of an employee in a specific position. Do you have to say what that employee did wrong that you needed to discuss in executive session? No, you don't have to say we've got allegations of sexual harassment. You don't have to say that in public. You don't have to put that in your minutes, but you've got to at least put what's in the statute. And then subsection H in the executive session reason statute gives school boards broad latitude to talk about problems involving students, parents, or teachers. That is much broader than other boards have. And that's a recognition that, you have FERPA and other privacy issues to deal with, and you need that wide latitude sometimes. Here's an example of a case we had involving the executive session reasons. The newspaper, the local newspaper, didn't like it that the school board allowed members, select members of the public, to remain in executive session while the board interviewed candidates for the superintendent job. The bottom line here is that the board determines who stays and who goes when they enter executive session. And the board can allow members of the public or whoever they want to remain in an executive session and exclude other members of the public. The only folks you cannot exclude are members of the board. What about notice? I mentioned that the statute requires notice. It requires that the board provide notice to the public of the times and places of your regular meetings. That should be set in your minutes or in some sort of rule or other permanent publication. So your regular meetings will be noticed through some sort of standing written rule or something in your minutes. For anything that's not a regular meeting, a special meeting by any name, you've got to provide special notice. And you've got to do that within an hour of calling the meeting. So within an hour of the time you decide you're going to have a special meeting, you need to post that notice. It's got to be placed in a prominent place in the building where you normally meet. And you've got to put a copy of that notice in the minutes of that meeting. You got to keep minutes for all meetings, whether open or executive session. Those minutes have got to be recorded within 30 days of the meeting. That means typed up. And they've got to be available for public inspection during regular business hours. So the minutes are to show the public what you did in the past. If I didn't come to the board meeting, I should be able to go look at the minutes and see what the board did. Here's what the minutes have to contain: members of the board who were present and absent at the meeting, date, time, and place of the meeting, accurate recording of any final actions taken. That means the things you voted on. You've also got to record by individual member the votes that were taken. So that means I should be able to look at the minutes and tell how every member voted on every vote. You can't just say the vote was 3-2. You've got to list the names of each member that voted yes and each member that voted no. Now, if it's a unanimous vote, you can just say everybody who was present voted for the motion or something like that, because you've already listed all the members present. And then the minutes can contain any other information that the board wants to place in the minutes. Keep in mind, though, that as I said earlier, the minutes are intended to record what the board did, not what the board members said. Minutes are not supposed to be transcripts. You don't have to write down everything everybody said. They're just supposed to reflect the actions that the board took. Can you ban cameras and other recording devices from an open meeting? No, not a blanket ban. You can have rules that force people to behave, so to speak, in your meetings. They can't do things that are distracting or disruptive. They can't put their camera in the line of sight, blocking the view of other people or from the public or board members. You can't, in my opinion, ban phones, but you can ban people from making noise with their phones, ringer turned off, no talking on the phone, etc. So you can have reasonable rules to govern the conduct of people who attend your meetings. You just can't have a blanket ban on recording devices. Remember that members of the public have a right to watch and listen at a meeting. They do not have a right to talk at a meeting. Boards are encouraged to allow time for public comment, but my best advice there is have some rules and stick to your own rules. Don't let people talk longer than your rules say they can. I think this board let this lady talk for 2 hours to try to placate her, and she still filed a complaint. So you don't have to let members of the public talk at all. You can have rules about what they can talk about and how long they can talk. So have some rules and stick to your rules. Okay, Public Records Act. We've got a few minutes to try and cover that. This is a part of the law that we enforce that you probably won't have to personally deal with that much. This will be administrators who'll deal with this. Here's some basics. Just about every document at the school is going to be a public record. If it's related to school business or school function, then it's going to be a public record. That's because the definition of public record is very broad. Everybody has the right to inspect or copy public records. They don't have to have a good reason or be a resident of your community. You can recoup the actual cost of retrieving and copying public records. We're going to talk about that in a second. There's two basic types of exemptions. There are lots of exemptions, but two basic types, either an exemption that covers an entire document or exemption that covers information within a document. The law says if part of the document is exempt, then you have to redact the exempt information and turn over a redacted copy. And of course, we're talking about this because the Public Records Act explicitly makes charter schools subject to the Public Records Act. It says charter schools are public bodies under the Public Records Act. So the Public Records Act clearly applies to charter schools. Here's the process. It's very similar to the open meetings complaint process, although the enforcement is a little different. Somebody files a public records complaint with us saying they didn't get the records or they were ignored or you wanted to charge them too much for the records. Once we get the complaint, we send it to the school. Once we get your response, we write up a recommendation to the Ethics Commission that they either dismiss it or find that a violation occurred. We have the authority to do a private or in-camera review of disputed records, give them back to the school, and then say what we think about whether the records were exempt or not. That is oftentimes a very useful function for both parties. It's also important to remember that both parties in these complaints have responsibilities. Not all the responsibilities are on the school. The person requesting the records has responsibilities too. First, they have to request what we call an identifiable record. That means they have to describe it in a way that you know what to look for. Also keep in mind, it's not called the Public Questions Act. It's called the Public Records Act. People don't have a right to ask questions under the Public Records Act. They have a right to ask for documents or records. You're not obligated to answer questions, just to provide non-exempt public records. Your responsibilities at the school are to respond in a timely manner, first and foremost. The law says if you have public records rules, you can give yourselves up to 7 days to respond. You can also get 14 days or even more than that by agreement with the requester or by giving a good reason for the delay. The main thing here is to communicate in good faith with the person requesting public records. As long as you keep communication open, it cuts down on problems, it cuts down on complaints to us. You also need to try and document those communications by doing most of it in writing. Email is a great way to communicate with requesters, although sometimes you have to pick up the phone and call them because you don't understand exactly what they mean in the email. But try to complain with us. You can provide us with those emails and we can see that you were communicating in good faith. Anytime you deny a request for public records for any reason, you have to deny it in writing. To say we don't have what you're asking for is a type of denial. And so even if they didn't make their request in writing, you still have to deny it in writing. We, of course, recommend that you require a request be put in writing. You can have a form for public records request that encourages the requester to give you the information you need to go find the records that they want. Cost is always a big issue. You can require prepayment of the cost. What you're supposed to do is create a reasonable estimate of what you think it's going to cost to provide the records that they've asked for. And you can charge for these 5 things: searching, reviewing, redacting, duplicating, and mailing public records. So what's it going to cost to pay an employee to go find the records, to review the records, to redact any exempt information from the records, to copy or scan the records, and to mail the records? So you're supposed to come up with a reasonable estimate of the cost of those 5 things, provide that to the requester. They're supposed to give you a deposit before you do the work. So you're supposed to estimate these expenses and give them that estimate on the front end. Don't start doing the work or incurring expenses until they provided you with a deposit. As far as labor costs are concerned, the law requires that the cost for searching, reviewing, and redacting records have to be charged at the rate of the lowest paid person competent to do that work. Sometimes you may have to charge for attorney's fees because you may have to get a lawyer to review some records to make sure they're not exempt or privileged or confidential. You can do that, but you can only charge lawyer fees for work that a lawyer has to do. If it's something that a lower paid person can do, then you have to charge it at the lower rate. Copy costs, we say 15 cents a page is reasonable. If you're charging more than that, you're going to have to justify why it costs more than 15 cents a page to make those copies. In this case, the university did the work, provided the records, called the requester and said, hey, we got your records ready. That'll be $600. And she said, forget it. That's too much. I'm not paying that. They never got their money. So they did the work and never got reimbursed. The moral of that story, as I said earlier, don't do the work until they provide a deposit in response to your cost estimate. The appeals court a number of years ago said that charging too much is an illegal denial of public records, and it can subject you to fines and attorney fees. So don't charge more than your actual cost, and make sure that you correctly calculate your estimate. I mentioned a minute ago, sometimes you have to get a lawyer to review something. In this case, it was legal bills. You can charge the lawyer's fee to the requester for reviewing those legal bills and redacting that exempt information. I mentioned there are lots of exemptions. Here are a few that are in state statute. Academic records, that's sort of a state version of FERPA. Everybody's familiar with the federal privacy law, FERPA, that's going to cover a lot of your records. Anything that your attorney does is probably exempt. Tax records like W-2 forms would be exempt. If you have any sort of licensure applications or any examinations that you require people to take as part of an application procedure, that would be exempt. That would probably also be a personnel record with regard to your employees. So personnel records are exempt. Things that other parties file with you could contain their trade secrets or their proprietary commercial or financial information. There's a process for working through that. Workers' comp records on your employees would also be exempt. What about personnel records? Here's a couple of examples. This guy asked for his own personnel file, and the statute that makes personnel records exempt says that you cannot release a personnel record unless the employee gives their consent. Here, where they're asking for their own record, they're giving their consent. At that point, though, once you get the consent, then it's up to you whether you turn over the record or not. So this guy asked for his own personnel file. The city said, no, we don't want to give it to you, and that was okay. This case at the bottom here, the newspaper asked for letters of non-renewal, which is what I call the pink slip. That's a form you may be familiar with that traditional public schools have to provide to their employees when they are not going to be hired back for the next year. The statute that requires those also says they're exempt, but the newspaper also asked for a list of employees who received those pink slips. And we said a list of exempt information is also exempt. So if you can't get the pink slip, you can't get the list of the people who got laid off. Here are a couple cases involving FERPA. This was a companion to that last case we talked about. To comply with FERPA, student information has to be redacted from records so that individual students cannot be identified. That's not always as simple as just taking out their names. You got to take out any information in that record that anybody in the community could use to figure out which student you're talking about. So that's very careful. You got to be very careful with that. It can be very tedious and can have high stakes. You always need to consult with your attorney when privacy issues come up. Here in this bottom case, education records that were covered by FERPA can be disclosed without consent if, again, personally identifiable information is removed. That's any information that could be used to identify individual students. We have created model public records rules for use by public bodies and people who are requesting public records. They're designed to be used by any state or local entity. It's a one-size-fits-all thing, so you'll need to modify those to suit your needs at your school. But they provide guidance to both parties on questions that are not answered in the law. We don't have a whole lot of public records law in Mississippi. I think there's about a dozen cases in the statute. And so the purpose of the model rules is to sort of fill in some of those blanks on questions that have not already been addressed. Those model rules are posted on our website. All these cases we talked about today are posted on our website. So we built a pretty substantial body of law that answers a lot more questions The courts have even cited these model rules and basically said they give you safe harbor. If you adopt our rules and you follow our rules, then you're not going to have any problems with the Ethics Commission or with the courts. So they're a great resource to protect schools from public records violations. This is our contact information. That's probably the best information I can give you today. We're not hard to find. You can Google us. All this information is on our website. Our contact information is on the website. If you can remember Mississippi Ethics Commission, then you can find us, and we will be glad to help you anytime you have any questions about any of the parts of the law that we deal with. So speaking of questions, any questions at this point? I think I'm out of time. Lisa, as an ex-school teacher, will probably make me stop, but
We're good.
but she's probably also happy for students to ask questions. So I'm guessing y'all are free to do that now.
Absolutely.
Well, if you think of questions later on, you can email me at that address on the screen. You can call me or get in touch with Lisa, and she can get in touch with me with anonymous questions.
Yeah. And guys, you can type a question into the chat if you'd rather do it that way. Feel free. This is your time.
I did have, while everybody's formulating their questions, I did want to ask about advisory boards, if there's a difference in any of these laws for boards that are just advisory to a charter school board, if there's any, I guess if there's any difference there.
Yeah, there certainly could be. There are some provisions in the ethics law that exclude certain types of advisory boards. We've not been asked a question like that specifically about a charter school advisory board. But as I said, there is precedent for saying that people in an advisory capacity are not subject to the ethics law, certainly, and probably not subject to the other laws, although they could be subject to the Open Meetings Act if they are created by the board. You remember those two cases I showed in distinction to each other? One was where the superintendent had created a group of people to advise him on some issue, and we said that's not a public body under the Open Meetings Act. But if the board created the group, then it probably is a public body. So that's one of the primary distinctions we'd have to look at.
Okay. That's fair.
Tom, can I follow up on that question then? If we have a school that, or one of our schools that has formed an advisory body outside the governing board itself,
Mhm.
if we had a question about that, or they had a question, would we just need to formulate that and seek an ethics opinion on it?
If it's purely an open meetings question, we would not be able to issue an advisory opinion. We don't have that authority under that law. It's only complaints, but we're happy to informally answer questions anytime.
Okay.
And I can do that in writing. I mean, you can call me, you can email me, and I can tell you what I think.
Okay.
If you really need legal protection, you'd need to go through the AG's office with that. So that the only advisory opinions we can issue are under the ethics law, not open meetings or public records.
Okay, good to know. Other questions from anybody?
I have one question. Can you hear me?
Yes.
Okay, are board members or advisory board members allowed to receive a stipend or payment for their services?
I don't know of any prohibition against advisory board members receiving a stipend or other payment. Depending on who's paying it and how much it is, there could be some ethics issues, but it's certainly not prohibited for them to receive it.
What about board members? For example, for monthly meetings, are we allowed to receive a stipend for monthly meetings, to get paid for monthly meetings, or is it only volunteer to be on a board?
It certainly would not violate the ethics law for board members to receive payment for their service. I don't know much at all about accounting of any type, much less accounting in charter schools. So, Lisa would probably know a lot, certainly know a lot more about that than I would. I don't know what sort of limitations may be placed on those payments in the charter school law or other law, but it's certainly not prohibited under the ethics law.
Okay, thank you.
Other questions?
I have one question, Tom.
Yeah.
Because I think we've been told a couple of different things, and I just want to make sure that we follow this at, to the letter of the law. But if we were to have a special called meeting, do you have to have a board meeting to have a special called meeting? I mean, you have to, how does that roll out? You know, I know you
That-
have an hour notice and all of that. So how does that
Mhm.
happen?
That would depend on your internal rules.
Okay,
And I'm not aware of anything in the charter school law that specifies how charter school boards are supposed to go about that. So I'm assuming in capital letters that each board is free to have their own policies and procedures about how to call a special meeting. The Open Meetings Act doesn't specify either. I mean, because the Open Meetings Act applies to every kind of state and local board and commission, it has some mostly very general principles. So the Open Meetings Act doesn't say how you have to call a special meeting. It just says what you have to do when you call a
Okay.
special meeting.
thank you.
Sure. But to keep in mind or kind of reiterate what I said earlier, when you do call a special meeting, just remember that you have to very quickly provide special notice by posting that notice in the building where you normally meet, basically put it up on the front door of your office. And then you have to put that copy of that notice in the minutes of that meeting.
So can the chair call a special called meeting, then you post it, you notify your board members, and then whether or not it actually happens is dependent on the quorum and so forth and so on? Is that okay?
Yeah, exactly. And that's the way we do it in our agency, because we're similar to the way I think charter school boards are. We're free to set our meetings whenever we want and however we want. The ethics law doesn't really specify. So we have a rule that says the chairman can call a special meeting. And so if usually the way it works is somebody in our office becomes aware that we need a special meeting. Somebody's got some sort of request that's urgent. It doesn't happen very often, but something that might justify a special meeting. I contact the chairman. He makes the decision. He calls the meeting, usually by sending me an email, and then I notify the other members, and I immediately go stick up the notice on the front door of our office. So, that's kind of a simple, common sense way to do it, I think. And I don't know of any reason charter school boards
That's
can do the same
really
way.
helpful for us too, as a state agency, because we've been
Mhm.
told some different things in terms of how that has to happen. And so getting some clarity on that for us is really important. So I appreciate that.
I mean, the best thing, in my opinion, the best process is one that's simple and straightforward and easy to use in a time crunch. I don't think we had a rule like that until after Katrina, if I remember, Hurricane Katrina, if I remember correctly. And it's we got two people on the coast. Our chairman is one of those, and I think we had two people on the coast at that time when Katrina struck, and we couldn't get in touch with them for a while. So you got to think about those kind of contingencies and try to have some sort of mechanism for continuing to conduct business in situations like that.
Right. Okay. Other questions from anybody? Okay. Well, I hope this was helpful. Tom, thank you. And folks that are on the call, if you can hang tight for just a second, we have a special guest that I want to be able to introduce you to. But we know where to find you, and appreciate all your time and expertise, Tom.
Sure. Anytime. Glad to help.
Thanks so much. All right. Okay. Sanford, are you there?
Yes.
Okay, great. Great. You have a few folks here. You've got Republic and Ambition and Midtown represented. So not all of the schools are here on the call. I think maybe Instant Impact might be here. I just don't see them. But anyway, welcome. And if you would just introduce yourself and then kind of share your thoughts and ideas, and hopefully they'll be as excited as we are about this possibility.
For sure. Hopefully I'm not, we're going straight from the ethics committee to virtual reality learning. So just quick switch. First of all,
pivot.
does anybody here, just a quick show of hands or a comment, have any of y'all heard of Labaki before? Do we know? Okay, Christy, cool. Great. So I'll kind of give you all a quick rundown and kind of tell you kind of how this call came about, kind of what we're hoping to provide for y'all. So we're Labaki. We're about a 4-5-year-old company based in downtown Jackson. We produce and create virtual reality software for K-12 and CTE learning. So a really cool visual learning experience. So we have, probably since you might have seen us, Christy, we have created this massive catalog for K-12 and for CTE of over 500 virtual reality experiences. Most of them we have made here in our house, in our development studio, which is right behind me. We've got it organized by grade and subject level. We've got it covers all the subject areas. We've aligned it with the MDE's curriculum standards. So kind of the way to think about it. And I shared those catalogs and some videos with Lisa before this. And I'll let her distribute those. Yeah, but we'd love to do some demos for your individual schools so you kind of see. It's kind of hard to explain unless you're in there. But basically, the way it would work is, let's say the 7th grade or the 3rd grade, whatever it is learning about a plant cell or the cell system and all the different parts that go inside of a cell. That teacher would already know that there is a virtual reality lesson plan and software that her school provides. So she would check out the cart from the administrative office, wherever it would be. The virtual reality card, just like the iPad card, would go to that classroom. All the kids would put on their headsets. The teacher would then run it all through their computer. So the teacher would run the program that all the students would be inside of out in her classroom. She'd be able to take them into the plant cell or all the other material that is in there for her grade and subject area that she wanted to. So that's kind of what it is in a nutshell, of kind of being able to explain it in this setting. But we've done a lot of homework and we've done spent a lot of time and effort putting together this catalog, and it's really, really extensive. And it's really fun. So our stuff is, yes, it's super fun and engaging and really exciting for the kids and the students, but we've also done a lot of work to make it as simple and easy to run for the administration and for the teachers as possible. So that's kind of who we are in a nutshell. We're super proud and super intentional about building our company here in downtown Jackson. We're obviously the only virtual reality company in the state, really in the Southeast. So we're having a lot of fun and we're growing constantly. So we're hoping that we're creating an environment for potentially some of your students that are gifted in software development to come here and work for us one day. So we're really hoping to grow and really excited about kind of our future and what we've got going on. We really haven't taken this to the national level yet. We're not quite, we don't have the capacity right now, but B, we really want to win big here in Mississippi before we really try to take this outside the state. So obviously being a part of the charter schools would be a major thing for us that we'd be really excited about. So I have begun working with Lisa about potentially identifying some federal funds to pay for what we call a classroom bundle for each of your charter schools, which would be 20 headsets, 3 years of the licenses and all that. And we do a full training. I mean, we don't just drop these off and say, figure it out. I mean, we do a very in-depth training implementation strategy for your school. So we're working on getting that. And after kind of going through y'all's website and kind of doing a little bit of homework on my end, I did see, there are a few of the charter schools that are just kindergarten and 1st grade. And I don't think that would be a proper use for them to go to those schools. But everything else would be really cool. And our catalog does say K through 12, and there is a lot of like 3rd, 4th, 5th, 6th grade, all the way to 12th grade. But all of the content on there can be used by any student of any age. That's just kind of how we have organized it through MDE's curriculum standards. So it doesn't have it's not a box. You don't have to stick it directly in that box. It can kind of be whatever your students are interested in. So I know that's kind of a lot of crazy information I just threw at y'all real quick, but I'm open to any questions. I hope that y'all would be cool with that. I mean, if we were able to find these federal funds for all your schools to get our program, we would hope that would be an exciting thing for y'all. But if not, no big deal. I just want to and if anybody wants to come to our office at any point in time, we're right here. We're right next to JPS, the central office. So I'll make sure that Lisa gets my contact to y'all. And if anybody wants to come learn a little bit more, do a little demonstration, we're right here downtown for y'all to come check out.
Thank you, Sanford.
Yeah.
I appreciate that. I told him when we first started talking, I said, okay, you have to understand different structure than traditional schools. So we're not going to be able to go in and say, hey guys, here's what we're doing to you. This is going to be all about what you guys are interested in and need and want and all. So I'm happy to make connections. Like Sanford referenced, we're going to try to get some money to help to at least get you, if you're interested, a classroom set of the devices and the software, and so you could have access to that to supplement what you're doing. This is not to replace anything. This is a supplemental too. JPS is doing this. I don't know in how many classes they're actually doing it, but I think WLBT did a really nice not article, but a nice news
Piece. Yeah.
on it. So
Yeah.
anyway, I'm happy to help and connect folks with Sanford. And if you guys are interested, you just let me know.
For sure. So it is a full like supplement to the classroom. It is not like, hey, you're not going to teach the whole lesson in virtual reality, but you can take kids. I mean, there's so many field trips and really, really cool things that are part of our program. That's just really fun way and engaging for kids to get in and learn a different way. I mean, we're so visual now that this is really just a fun and unique way, and it's a really new way for our students to learn. So, that's the K-12, but we have kind of our other CTE and career pathways catalog, which will be awesome for your students to get in and explore all the different, career pathways that they can go down, working on an oil rig, working as a real estate agent. We have a ton of really neat kind of day in the life experiences in there that are really fun to watch in virtual reality that might get one of your students really interested in something they never thought about being interested in before. So anyway, that's kind of in a nutshell what we got going on.
Yep. Thank you. Thanks.
Yeah.
All right. Any other questions from Tom's presentation or for Sanford before we shut down today?
If I can, I'll give a quick plug for Lubbock also. I went on a tour with my daughter to look at some other schools, and there was a virtual reality, program in place at Jackson Prep when she went to look at it there. Also got very engaged with Adam Mangana, who now has his own classical total virtual reality school down in Florida. It's what's coming. It's what's here now, to be honest with you. It's a very, very, very good way to meet the kids where they are. I'm sure we know all the kids at some point in time in the day have a device in their hand. And this is how they learn now. It's not the traditional manner of, I'm probably telling my age of how I learned and how other people learn. And I think this is a great place of how we have to meet our kids where they are now. I encourage everybody to either go down to Lubbock, like he said, or, I don't know if there's an opportunity to go out to any other schools where this is currently in place in a virtual reality lab or something like that. But it's a wonderful tool. And I just wanted to kind of throw that in there.
Thank you.
Thank you, Marcus.
Yeah. And Sanford, maybe we can just get a poll, from everybody. And of course, everybody's not represented here. Maybe there's some interest in coming down and touring, your facility or going to a classroom and having some more conversation when it's time.
Yeah.
It's spring testing. So probably not right now. Probably
yeah.
not
We're
the next few weeks, but sometime soon.
We're going to hope that this is kind of setting in place by the fall, beginning of the school year, right? So we've done all our stuff over the summer. You've gotten kind of a chance to learn it and test everything out. And then by the fall, y'all are kind of ready to go.
Well, we're excited to partner with you guys and see what we can do with the schools. So thank you for that.
Yeah.
Hey, Lisa, do you know what the time frame could be on that in terms of?
What we talked about, the money piece, Sanford was in DC yesterday, and so he's been working on that, having conversations already. So I don't know what that would look like going forward. I don't know how far they are, and I don't want to speak out of turn, but I know he's already working on that, trying to get some support for you guys. As far as implementation, we also talked about you know, making sure that we take the baby steps to get there and look toward the fall for an implementation for schools that want to do it.
Yeah.
Thank you.
We do a full like in-person, really in-depth training for every school. Each school kind of names we try to get each school to name a champion. So we train that champion in addition to maybe some of their staff, really get them used to it. And then we like that champion to then kind of maybe do a presentation at a staff meeting at a school to distribute the material and basically like, hey, please check out your grade and your subject area and see what content there is, and then kind of come to us and we'll kind of teach you how to do. Does that make sense? And then, but anyway, it's not like we're just dropping these off and saying figure it out. But then, yes, we're working on finding some money that basically y'all just say thanks. That's really kind of all we're wanting. So we really don't want anything on y'all and basically other than using it, you know. So we're trying to really work on it and just to be a good partner of ours, right? I mean, that's what we're looking for, and we're really excited. We hope that y'all are proud too that we're kind of doing this here inside the state. That's kind of we're kind of like a purple cow. You know, people are not used to companies like us, but we're proud of that. And Marcus, yeah, I'm glad that you saw what they got going on at Jackson Prep, and the other schools. And Manjana, yeah, he's doing a really cool, kind of real deep metaverse kind of for homeschooling across the country, and he's down in Florida doing that. But I will get that news article over to y'all as well that you can check it. I think I might have linked that to you as well, but I'd love for all y'all to at least, we've got Lisa has our catalogs. If you'll start scrolling through them and you'll probably be hopefully really impressed by what all is encompassed with it. It's really, really extensive and we didn't really leave anything out.
Thank you so much. All
Yeah.
right. Anything
Great.
else for the good of the order? All right. Well, thank you guys for being here. Thank you, Sanford, for popping